SJC-12067, Commonwealth v. James C. Hardin.
Good morning, Mr. St. Lawrence. Good morning. You surprised me by being on that side. I'm not used to that. Give us one moment, and then you may begin.
Chief Justice Gantz, honorable justices, may it please the court, Timothy St. Lawrence for the defendant appellee, James Hardin. A judge of the Boston Municipal Court dismissed 2 counts of a 4-count complaint against Mr. Hardin on the basis of lack of probable cause for those charges. The Commonwealth appealed. On appeal, we're arguing that an alternative ground for the affirmance of the orders of dismissal is apparent on the record, and that is that the criminal complaint was facially deficient, that it did not give fair notice to Mr. Hardin of the nature of the accusation, did not allow him to prepare a defense, and would not allow him to plead double jeopardy if he was re-prosecuted in the future for the same offenses.
Now, isn't that why the Lord made a bill of particulars?
No, I don't think so. I think when you're supplying essential information, which we suggest this is, it has to be in the criminal complaint itself. I would suggest to the court that this is a 4 corners face of the criminal complaint. I would cite Commonwealth versus Clark out of this court for that proposition. I would suggest a bill of particulars can narrow a criminal complaint, get down into specifics, date, maybe if it's not in the criminal complaint, place. Bill of particulars, you can get the theory of the case if it's a joint venture theory of the Commonwealth, a principal theory.
How do you interpret in that regard, I'm confused by this, Chapter 277, Section 34?
Okay.
Which is the one, an indictment, I understand this complaint, but shall not be dismissed or considered defective or insufficient if it's enough to understand the charge, or nor shall it be considered defective or insufficient for lack of any description or information which might be provided by requiring a bill of particulars.
Well, the way I read that is that the complaint first has to be sufficient on its face. Now, if you're trying to dismiss a complaint that's sufficient on its face based on a piece of information that you properly can get from a bill of particulars, then that's not going to be a successful motion to dismiss. But when you start with a defective complaint on its face, you can't cure that. But if it says,
are you talking now about the breaking and entering or the larceny or both of them?
I would suggest to the court that both are fatally deficient because they don't descend into any particulars. There's no allegation, and this would be simple for the Commonwealth. Describe the property that was broken into or stolen. They had that information, or name the owner. Sorry.
Okay, but on the larceny one, if it uses the word steal, it's somebody else's property, right?
Sure.
But isn't that exactly the kind of thing that a bill of particulars could clarify? What is that property?
It certainly could, but I don't think it would save this complaint.
Okay.
So is this the case with regard to every complaint, that it must identify the name of the victim?
No, I would suggest to the court that it just needs to put the defendant on fair notice. And to do that, the statute says, in the cases of property, either describe the property, which is pretty simple, or name the owner of the property, one or the other. And it's a sufficient complaint, fair notice. But when you do neither, you're left with a situation where the defendant has no way to prepare a defense because what is he really charged? What is the nature?
Does it matter that, as I understand the facts, that the application for the complaint has the police report attached to it? Does that make any difference here?
Right, so the application for the complaint was basically the police report. And again, I would suggest that what we're looking at is just simply the complaint. the face of the
So you
complaint
can't- you
without
can't
the
take out-
application.
You can't take into account the information that went into getting that complaint.
Right, that's what I would suggest to the court, that it would just be the face of the complaint. The complaint, I mean, it's a powerful piece of paper, and I think we have to hold the Commonwealth to, what I don't consider an overly burdensome standard of putting the defendant on fair notice. Now,
Could it be, I'm sorry, I missed it. Could it be satisfied by saying the property of another person or the motor vehicle of another person without identifying the person?
I would suggest no, that would not be sufficient. And I'm citing to Kalinowski and the statute, I think it's 277-35, that's pretty plain, that says when we're talking about a property crime, we're either going to describe the property itself or name the owner of the property. And that will be a sufficient complaint. But with neither, we're left with a situation where it's basically just the statute written out, not even in this case, but even if it was just the statute verbatim, that gives the defendant no chance, if he were re-prosecuted down the line for the same offense, to pick up this piece of paper, this complaint, and say, look, I've already been prosecuted for this crime. He can't do that with this complaint. And I think that's a problem. So that's the argument. We also make the argument that with respect to the breaking and entering, and this is kind of a fallback, and I don't think it's as strong, but I just wanted to mention it to the court, that it is missing an element where it doesn't even say that it's the property, that he broke into the property of another. And I know that there's cases that say not every essential element needs to be put in a criminal complaint necessarily. I think when the gravamen of breaking and entering, and this is from Kalinowski, is that it's the property of another, that should be alleged in the complaint. And when it's not, that it's defective for that reason. And I would cite Paris, which is in the Commonwealth's brief, and Palladino, which stands for that proposition that essential elements, important. Now, and I know it's been carved out in some cases, but I think it would be a case-by-case basis, and where, again, it's the gravamen of this crime, it should be alleged in the complaint as well. Thank you.
Thank you.
Thank you. Mr. Hillman, good morning.
Morning, Your Honors. May it please the Court, Zachary Hillman on behalf of the Commonwealth. We're asking the Court to reverse the order dismissing the charges of breaking and entering and larceny under $250. The complaint here was sufficient to put the defendant on notice of the charges of breaking and entering and larceny.
What do you make of, how do you read that statute, the 277-34 and Clark together? I mean, what role does a bill of particulars play?
I think a bill of particulars, the role that a bill of particulars plays is to identify particular aspects of the charge that are not necessary in the charging document itself. And by that I mean, what the defendant has to have notice of under Rule 4 is the act with which he is being charged with, not the identity of the person whose property was stolen, the identity of a victim. It's the act which he has to have notice of. To the extent that there are other aspects of the charge that are subsidiary to the actual act, that's where the bill of particulars comes in.
With respect to at least the breaking and entering, one of the acts has to be that it's breaking or entering property of another. I mean, a building, right?
I agree with you, Your Honor. I would say in this case, this is a case that really calls out for the application of common sense. The application here has to be read by this court through the eyes of a reasonable, ordinary person using their common sense. And in doing so, in looking at the complaint in this manner, the complaint itself, the language using to describe the property here is it's a possessive noun. It describes that the property belongs to someone, and the fact that the body of the complaint charges the defendant with breaking and entering, the caption of the complaint charges the defendant with breaking and entering, is implicit in that is that the defendant is charged with breaking and entering into the property.
Because you don't, I mean, it's just implicit in it, you don't break and enter into your own property.
Absolutely, Your Honor. I would perhaps borrow a line from Justice Cass and say that it would be, you would require practiced obtuseness not to understand that you are being charged with breaking into the property of someone else. With respect to the argument that my brother makes as to the defendant not having notice of the charges here, he was aware of the act. The complaint set out the date and the act for both breaking and entering and larceny under $250. I would point out that the application for complaint told the defendant exactly what property it was that he was charged with breaking and entering and stealing.
But now, Mr. St. Lawrence says that isn't really fair to look at that. I mean, you've got to look at the four corners of the complaint.
I agree with him. You first have to determine whether or not the complaint is on its face valid. Here it's on its face valid because it adequately tells the defendant the act with which he is charged with committing, that is the breaking and entering on March 19, 2014, and the larceny on March 19, 2014. To the extent that he was looking for subsidiary details, the owner of the property, the property that was stolen, the name of the motor vehicle that he had broken into, all of that he could have obtained through a bill of particulars, and I think that's where Section 34 comes in, and that's what the cases say. It turns out in this case he didn't need to because all of that information was contained within the application for complaint, which is why I would suggest to this court he desired to plead guilty on the day that the charges were dismissed.
Now, what do we do with Chapter 277, Section 25? It speaks of an indictment. Is it your view that it applies only to indictments or that it doesn't apply at all?
I believe Section 25 applies to complaints just as it would an indictment. And again, 25 makes it clear that what has to be shown to the defendant in the indictment or the complaint is the act itself, not the name of the property or the description of the property. That's a detail that can be gained through a bill of particulars.
Wait, I'm sorry. If an indictment for a crime involving the commission of or attempted commission of an injury to property describes the property with sufficient certainty in other respects to identify the act, it need not allege the name of the owner.
Yes.
Sounds to me as if you need to identify either the name of the owner or identify the property with some particularity.
I read that, Your Honor, to say that the defendant has to be put on notice of the act with which he is charged. And I would cite Commonwealth versus Cantris, and I would cite Commonwealth versus Kalinowski for those propositions. If the description of the property is not contained within the charging document, so long as the defendant can understand from that document what the act is that he is being charged with, the name of the description of the property need not be contained within that document. That's something that can be contained in a bill of particulars.
So the extent the description was, did steal the property of known to Commonwealth. Was it necessary to say known to Commonwealth, or would it have been sufficient to say did steal the property?
It would have been sufficient to track the language of the complaint, steal the property of another, steal the property of someone else, property of, in this case, known in the Commonwealth, which, taken in conjunction with the body of the complaint and the caption of the complaint, told the defendant that he was charged with breaking and entering into the property of someone else. I would say that the name of the person whose property had been broken into isn't always necessary to be contained within the complaint. We may have concerns about witness safety. We may have concerns. We may not know the name of the person yet. So it's again, that's why I say it's the nature of the act itself that has to be conveyed, not the description of the property.
In response to Chief Justice Gantz, you said that the nature of the act, but if the statute 25 is pretty specific, so I'm not talking due process here, but just if it's pretty specific, why wouldn't the person swearing out the complaint have to comply with that?
I think certainly in a best case scenario, it would. And we tried to the best that we can to follow the description set out in 277, Section 79. But I think what Section 25 is getting at is, again, it's a question of notice. So long as the person is put on notice of the act, the name and the description of the property need not be contained. Or, I should say, the complaint won't be dismissed and considered defective because those details are lacking.
So therefore, on the larceny, it's hard to see how there could be a problem because it says steal.
Yes.
But in the B&E, there's nothing to indicate that it's the property of somebody else.
I disagree, Your Honor. I think just reading the complaint in a very common sense manner, the fact that the defendant is being charged with breaking and entering into the property of someone, I would suggest no reasonable person reading that complaint would think that they're being charged with breaking into their own property.
So when you teach your new crop of ADAs how to prepare complaints, is this what you would teach them to do going forward?
We would ideally teach them that to the best that the language can track the statutory forms as laid out in 277, Section 79, it should do so. A lot of these complaints are pre-generated by the clerk's office. The language is...
Does the clerk's office use known to the Commonwealth?
Well, no.
Where does that come from?
That came from the police officer. There are fields in which the police officer or the applicant for the complaint fills out. In this case, the police officer put known to the Commonwealth. He could have put another, and that would have been sufficient.
It would have been a lot better. I mean, I just don't know why that comes up in a field.
Right, we wouldn't be here. There are some fields, the date, the description of the property is a field that the applicant fills out. In a crime of attempt, I think the applicant has to fill out the overt act. But ideally, yes, when we're teaching our new crop of ADAs, we would have them go through and look at the statute and make sure that the complaint complies with the statute and tracks the statutory language.
All right, thank you.
Unless there are any questions, content to rest my brief. Thank you.